My name is Ana Maria Bazan. I'm an attorney who specializes in immigration law. As you have seen, on July 2018, there have been many changes and backlashes against immigrants, changes in policy and practice. Today, in this video, I want to discuss a new change in policy with USCIS. A memo dated June 28, 2018, and released on July 5, 2018. It essentially broadens the power of USCIS to issue notices to appear and place people in immigration proceedings. What does this mean? Well, it's giving the United States Citizenship and Immigration Service power to refer more cases to immigration court. As you know, there's a huge backlog. There's a crisis right now that we're experiencing in the immigration court. There's over 700,000 cases pending. This will increase the case. It will make the caseload, it will make it chaotic, and in my opinion, just crazy. It's going to be very difficult for the courts to take thousands of more cases. Any cases that USCIS will deny for whatever reason have to be referred to immigration court proceedings. They're mandated to do that. So that if they deny your naturalization, or they deny your adjustment of status, or if they deny your U visa, or your Violence Against Women's Act case, or whatever case, they're gonna refer you to immigration court proceedings. What does this mean for you? You should be ready. You should consult with an immigration attorney to see what defenses you could possibly have. Maybe it's just a mistake and you can just defend and explain the situation, but you really need to hire an attorney and understand what your defenses could be. The most common defenses in immigration court could be cancellation of removal. If you've been here for over 10 years, have U.S. citizen children, a spouse or a parent, or resident spouse or parent or child, you can maybe get a green card in court. You have to have 10 years of being here, good moral character, the relatives that I mentioned, and also you have to prove extreme hardship to those relatives. And it's not easy to get cancellation of removal. I'm just saying that it could be one of the defenses that you possibly could have. You could have an adjustment of status defense, that your spouse is a citizen or a resident, or your mom or your child is petitioning for you. You could have a defense based on a U visa. You were a victim of a crime and you can self-petition, or if you were a victim of domestic violence by your resident or citizen spouse, you can self-petition. There's many defenses that you could possibly have. Each case is different, so you must consult with an immigration attorney as soon as possible. Times are difficult right now for many immigrants from all over the world, and we need to document these cases, help each other, and find legal representation. Thank you for watching.